Welcome to the Consultation. My name is Josh Floyd. Here I have Christina Jimenez. We are attorneys here in the state of Texas at Jimenez Floyd PC, and Christina thinks that's funny. And today we're going to talk to you about
We're going to talk about
conservatorship.
Right.
Conservatorship, yes.
Good job, Floyd.
Joint managing and sole managing and the differences and all that good stuff.
Yeah, absolutely. So, as we always say, beginning, middle, and end of this podcast, this is not to be construed as legal advice. And so, if you find yourself in a legal situation as pertains to family law in the state of Texas, please find a local attorney, consult with them, tell them your situation, and then do what they tell you to do. Because if you listen to our podcast regularly or watch us, you know that the tiniest little nuance in a case can change everything. And so we want to make sure that you're using this kind of to educate yourself, but it's not to be construed as legal advice. Okay? So some of the other things that the court can consider is physical and emotional needs. I've had those situations in the past where the kiddos, I see this a lot, where the children have been diagnosed with like autism, and maybe the other parent, like maybe the father or the mother. I've had it actually both ways, where it was the father who was the only one that could really, calm the child or parent the child, and I've had the same thing where it was only a mother, and it wasn't the other parent's fault necessarily. It's just the way that things were, and that wasn't a reason for them to be appointed as a sole managing, or it could be a reason for them to be appointed as sole managing. What else? Anything else with physical and emotional needs?
I don't think so. I mean, there's a whole list of them, and I guess we're going to go through them, it appears. But and it's not just one factor by itself, right? The court considers all of these factors to make that determination. Because, like you're talking about the physical, emotional needs, right? You were talking about physical needs, right? Mm-hmm. The autism issue. Mm-hmm. Because in that situation, they could still name them joint managing conservator, mm-hmm. but make specific exclusive rights to one parent. So they're still joint managing, but give one a few more rights.
Right. Right. So you also have physical and emotional danger. You have stability of a home. You have the plans for the child, cooperation between parents, parenting skills, who's the primary caregiver. And those are some of the factors that the court can consider. We also have this stuff about false reports of child abuse, which we got to deal with this morning.
We've been dealing with that a lot lately. I don't know what's going on, and we've already done a podcast on it, so we won't dive back into it.
But
holy
I'm
shit,
pissed.
Stop.
But that is actually something that the court can consider when appointing as joint managing or sole managing. There's also international child abduction, promoting or interfering with the relationship between the child and the parents. Alienation is a big one, and I actually had a pretty big case a couple years ago. And it involved, now that I'm thinking about it, the false reports of abuse and also the parental alienation, where the mother just consistently, I think we had like 8 or 9 different reports to the department, and then we had different videos and audio recordings of this mother just bad-mouthing the father to the children. And in that particular case, the court made an affirmative finding of alienation and appointed the father as sole managing. And so, we go through these factors not only to kind of explain how to get joint managing and sole managing, but also for you guys to understand the things that you should not be doing, right? And obviously these things are...
Making false reports.
They're not in the best interest of your children, which is why the courts can go through and consider these things to say, listen, you don't have the ability to do the right things for your kids. And so now, instead of you having all of this, decision-making power over your children, I'm now going to strip you of what you were presumed to have, because that's where everybody starts, because you've chosen to act like a jerk and do bad things, right? So don't do the bad things. Think of your children at all times, and then everything's going to work out fine.
Yeah, again, it goes back to the courts want both parents involved, both parents making decisions, both parents working together for the best interest of the child. That's what they want to see happen. All of these factors just basically go to that. Like one parent can't do it or won't do it for whatever reason.
Right.
And that's when we look at a sole managing situation.
Right. And so When you have joint managing conservators, typically you have one parent that's going to be awarded the exclusive right to designate the residence, and then the other one will have possession and access, right? When you have sole managing, you're going to be looking at one parent having the exclusive right to designate the residence, and typically the other parent will have some sort of possession and access, okay? There are instances in which the court can deny possession and access altogether. I think that's a podcast for another day.
Yeah,
absolutely,
that's
because
a
we
whole
could we could talk a whole lot about that. But you will typically, as a possessory conservator, as the sole managing conservator, or as a joint managing conservator, you will typically have the same rights to information. Is that how you explain those first 9 rights?
No, I usually explain it in a much better fashion.
How do you explain it?
So, the way I explain it is basically the legislatures, they came up with this list of rights, and there's 2 main categories. I know there's duties and possession, but that's what I'm talking. 2 main categories. You have all of your information rights, and then all of the decision-making rights.
That's what I just said. The first 9 rights were
However,
information rights.
Under a joint managing conservatorship, both parents have both sets. Under a sole managing, one parent has both sets. The other parent only has the information rights.
So what I say is
not nearly as good as what I say. But go
no,
ahead.
but I always talk about the fact that in both scenarios you're going to have information rights. We're saying the same thing. We're just saying it differently.
I say it better.
But I think mine's better. But we're going to say it 2 different ways.
Vote
just
below
because
in this comment.
there's going to be a poll. No. So I always start off with the 9 information rights because that's the way the temporary orders and the final orders typically read. They start off with the information rights. And so the first is the right to receive information from any other conservator of the children concerning health, education, and welfare of the children.
That's correct.
Okay? That good?
Yep.
We're going to move on.
That's pretty
So
self-explanatory.
so here's what I always say on this particular one, is I say that the litmus test is if it's something you would want to know, then you need to be telling the other parent about that. Right? And so if you would want to know that your kiddo had 103-degree fever that had lasted for 24 hours and they're going to rush them to the ER or to the urgent care or whatever, then that's probably something that you should share with the other parent, right? If the kiddo has some sort of an infection or got bit by a dog or got sent home from school because they punched another kid in the face, those are the things that you need to tell the other parent. And it is beyond me when I have clients or when the other parents are withholding this important information from the other parent. And I'm telling you, it pisses these judges off, right? Like, hold on, you went and I had a parent who took the kiddo overnight to have a sleep study conducted so they could determine whether or not he needed to have his tonsils removed or was something like that. And my client knew nothing about it. And that was just appalling to this particular judge, because how are you going to do that and not share that?
Yeah, I generally hate the question of, do I have to tell them X? Like, why is it a burden? Just tell them.
Right.
Could you get away with not telling them? Maybe.
Right.
But why go down that trail?
Right.
I mean, just tell them.
Yeah. And we just had a case, a few weeks ago where so the father was coming in on a temporary basis to try to take the kiddo away from the mother, and he was alleging some sort of medical neglect. And through the cross-examination, we learned that he had actually taken this kiddo to all these different doctor's appointments to get all these diagnoses, did not tell mother about the doctor's appointments, did not share the diagnosis with the mother until such time as he filed an affidavit trying to take these kids away, or this kid away. And when that all came out, the judge was not happy, because that's important information that should have been shared with mom. You don't get to not share it and then try to use it against her, right? So just share the information, right? There's some really cool apps if you just don't like talking to the other parent, and I know that those are those are definitely situations that people deal with. So there's an app called OFW.
Our Family Wizard.
Our Family Wizard. You can sponsor us. App Close is also
The
another
OFW
one,
badges
right?
on there.
OFW. And so those are really good apps, and they're called co-parenting apps.
Did you
right?
say App Close?
I did say App Close.
Yeah.
And I'm sure that there's other, but those are the two that we primarily use, or our clients use. And it's really cool because you could go on and say, hey, just want to let you know, kiddo woke up with 102 fever, gave her some Tylenol, thinks she's cool now, just wanted you to know, right? Or, hey, took them to the doctor and this is what they want to do. Just, here's the next appointment. Make sure if you can be there, be there. Those are the things that are going to be, really, really good for you when you go to court if you do that.
And I know it's really hard to do when the other person's being a jerk, right? But always be the good guy, right? Overshare information, even if they're being a jerk, not responding, still do your part. That when we go to court, you're in a good position, the other person's a jerk. But if you start being a jerk also, now both of you are jerks and the court doesn't care.
Right, right. So,
Well, I mean, the court cares that you're both being jerks, but
I'm not going to care about your position.
Right.
So the next one is the right to confer with the other parent to the extent possible before making a decision concerning the health, education, and welfare of the children. And so, I kind of laugh because it's to the extent possible, right? Sometimes you're just not going to be able to talk to the other parent, and we get that. Like, we're not, we don't have our blinders on. We know that it's sometimes super, super difficult. But again, like Floyd says, if you're going in and you're doing the right thing and then they come off as being, assholes, then that's on them, and the judge is going to see that, right?
this right always confuses me, right? So it says that I, Josh Floyd, have the right to confer with the other parent, right? It doesn't say that the other parent has the right to be conferred with, right? It just says that I have the right to call them and talk to them about it. Of course I do. I call and talk to anybody I want. So I don't really understand that right's confusing me.
The right to confer with the other parent to the extent possible before making a decision concerning. So before you, Josh Floyd, make a decision as it pertains to your child, you have the right to talk to Mrs. Rochelle Floyd, or I guess Miss, if y'all were doing all this, Rochelle Floyd, before you made a decision regarding health education.
Of course I do, right? But
Right.
it doesn't say that Rochelle has the right to be conferred with by me.
Right. I guess that's true. Okay. So
Just telling me that I have the right to
understand
call and talk to somebody about it. Yeah, I know.
and you should, though. I think that's
Doesn't
the
say that.
point. I
Doesn't
know,
say that.
but you should, right? Please do.
It doesn't say you should confer. It says I have the right to.
And so this is another way, though, that I see people getting in trouble is they go and they make these major decisions. They're pulling kiddos out of school. They're, making major health decisions for the kiddo, and they're not talking to the other parent before they do it. Right? And so just make sure that you're doing it. And so even though, let's just say hypothetically speaking, that you call the other parent and you say, listen, I took the kiddo to the doctor and kiddo needs to have his tonsils removed. And the other parent says, well, F you, I don't agree. I'm not going to, do this. So I'm not going to give you my consent. Then, what I would typically say is we'll give them the doctor's information, give them some time to confer with the doctor. And then if they don't take the steps to talk to the doctor, maybe get a second opinion, I don't think a court would hold that against you if you move forward with that procedure, so long as you're sharing the relevant information.
Yeah, and certainly if it's something that's recommended by the pediatrician.
Right.
Right.
So next is the right to access medical, dental, psychological, and educational records of the children. Okay, so I have this happen a whole bunch of times in my cases where sometimes they have a prior order, right? And in this prior order, typically will say that they have the rights to get this information. And lo and behold, my client goes to the school to try to pull the attendance records because, they're thinking there's some things going on. And the school says, oh, well, sorry, we can't give you these records because you're not on the paperwork. Or the doctor says, we can't give you this information. I always instruct them, take your order, show them your order, show them on this page where it says you have this right, and they should, at that point, release the information to you.
Does that ever work for you?
It has worked for me several times. No?
A couple times I've tried it. I get a call from the principal or something, and they're like, well, the order says this, this, this. It doesn't say this, this. I'm like, nah, no, the order says you have to give them the stuff. And they're like, well, I'll have to refer to our attorneys.
I feel like you need to just call me, conference me into that bad boy. I got you.
Yeah, sometimes they can be pretty difficult.
No, I've never had that issue before. Yeah. So you have that right. So I always tell them, take the order. So right to consult with a physician, dentist, or a psychologist of the children. Pretty easy. You can talk to your doctors. The right to consult with school officials concerning children's welfare and educational status, including school activities. Also pretty easy. You can talk to doctors, principals, teachers, etc. Regarding the kiddos. So this one's newer, right? It didn't used to be the right to attend school activities.
Correct. It was just generally the next one that encompassed the activity stuff.
Yeah, so the right to attend school activities, including school lunches, performances, and field trips. And so this one...
It's tricky.
It's always tricky. You gonna talk about it?
Sure, we can talk about it. So the portion of this, so to clarify, these are rights of parents at all times, right? And so if a parent has supervised possession, can they go eat lunch with the child at school?
I thought you were going to talk about it.
I don't know.
You're not saying anything.
I just had an answer. Right?
So typically what I will do, and I don't know... So typically what I think that you could do in that particular case, if the parent only had the supervised possession and access, is I typically will add in like something that says solely in conformity with the possession and access as stated in here. Correct. Right. And so I will typically put a caveat in there because my position is if the court is saying you can only see these kiddos at a facility for a couple of hours each time, they don't want you going to the school. They don't want you going to school, to lunches, performances, and field trips, right? Now, I would say that on the times when my client is afforded supervised possession and access, that is something that I clarify, because I have had judges who will say, no, they can go to school activities, they just can't actually take possession of the child, right? If they're at school, or if they're at lunches, or if they're at these performances, they're in the crowd and they're watching, and so I don't believe that that is a danger to the children. They can be there. I just don't want them having sole possession of the kiddo and the ability to remove the kiddos.
Yeah, and that's really fact dependent situation, right? Because if the danger is, you got one parent, that's doing drugs and stuff like that, and therefore is a danger to the child based on that kind of stuff, right? If they're in a public environment, the chances of the child being injured are not that great, because somebody will see it and stop it, particularly in a school environment. But if the danger is talking crap about mom or telling the child inappropriate things, stuff like
or
that.
Or physical abuse, sexual abuse, those types of things.
Yeah, stuff when they're seeing the child that would cause the child emotional harm, right, to have to see them after something like that. Then the court's more likely to say, no, you don't need to see this child at all except for in the supervised facility. So.
Right. And I just think as attorneys, it's important that we're asking those kind of tough questions because you want to make sure that you have clarification either end that you're on, right? So the right to be designated on the children's records as a person to be notified in case of an emergency.
Oh man, this one bites people in the butt so bad. Like, when you register the child for school, put the other parent as the other parent and as an emergency contact. I love getting them when I'm on the other side and I see, like if I represent dad, I see mom as the parent and then step parent.
Right.
But dad?
Or grandma.
Yeah, or grandma. Or friend, neighbor, whatever.
Right.
But dad, nowhere on there. I'm like,
right.
Oh,
Yeah.
I love it.
Judges don't like that, guys. They just don't like it. And so make sure your paperwork's proper. And if your paperwork is not proper, as you sit here listening to this, just run down to the school and let's make some changes real quick.
Before we get hired.
Right.
And if that's the problem, though, because I could see in some situations where you wouldn't want the other parent contacted in case of emergency, go to file a modification and get that fixed, because you're violating the court order by not putting it on there.
Right. So next is number 8, the right to consent to medical, dental, and surgical treatment during an emergency involving an immediate danger to the health and safety of the children.
Yeah.
So this is interesting because, as we stated, these information rights, if you're joint managing or sole managing, if you're the possessory, you're going to have these rights, right? And so I just think that the reason why this is in there is, like, Lord forbid, something happens and kiddo's over at grandma and grandpa's house, and maybe mom is in Europe with her new husband on a honeymoon, and something, happens to these kiddos.
She married up.
And so, and dad's still here working in the States, and something happens and this kiddo, has some sort of an emergency. Possessory dad, who only has supervised access, would have the ability to make those decisions if it was an immediate danger to the health and safety of the children. So you have that at all times.
Yeah, I mean, there's like 3 different provisions about medical decisions in these orders. You'll hear about them, but...
Right. So the next one is the right to manage the estates of the children to the extent the estates have been created by the parent's family or by the parents, other than by the community or joint property of the parent. So.
Yeah, so if the child has any property, whether, a trust or...
529s we see a lot.
Yeah, 529s, bank accounts with money in it for whatever reason. If they've got jobs, you put them to work at 12, Yeah, if they, anything by will or whatever, yeah. So if they got any estate, you have the right to manage it.
And so the next thing that we have to talk about are these affirmative duties. And so you were talking about earlier about how you were confused on that last one about the right to talk to. This is the one that I was thinking.
Yeah.
Yes, this one I was thinking of. So this is affirmative
Not
duties.
Like duties.
I knew. Why does he go there?
You said duty.
D-U-T-Y. The duty. You have a duty to inform the other conservator.
I need the poop emoji.
Oh my God, Floyd. The duty to inform the other conservator of the children in a timely manner of significant information concerning the health, education, and welfare of the children. Right?
Yes.
So that's kind of going back to what I was saying earlier. Something major, litmus test. Make sure that you're sharing that info, you're documenting it. Otherwise, you can find yourself in a bad situation. So the next thing is all of this stuff on protective orders and sex offenders. I don't know that we want to go through and break all that stuff down.
No, just basically what it says is if you intend to reside with or marry a registered sex offender, let them know. If you yourself have become subject of a final protective order, or if you allow the children to be unsupervised around somebody that's subject of a final protective order, let the other parent know. If not, it's a criminal offense.
And those are typically as it pertains to sex offenders and people who have had final protective orders rendered against them. And so I just tell my clients, if ever you find yourself in any of these situations, you need to go to your order, you need to review it, because there's time frames when you have to notify the other parent. And if you don't, then it's actually a Class C misdemeanor.
And I tell my clients, if you find yourself in this situation, call me, and I'll tell you whether what you're planning on doing is a good idea or will result in a modification, you losing custody.
Right. So, next is these other rights and duties.
During possession, right?
Well, so there's duty of care, control, protection, reasonable discipline.
That's the 4 during rights and duties during possession, right?
Okay, yes. So, duty of care, control, protection, reasonable discipline, easy. Duty to support the children, including clothing, food, shelter, medical, dental care, not involving invasive procedures.
So that comes up when, do I have to send clothes with my kid to the other parent's house? Technically, right? Each parent during their possession are required to provide their own food, clothes, shelter, but don't be a jerk. Right? Send a bag of clothes. Well, I never get them back. I understand.
Yeah, I know. I have those issues that come up a whole lot, and yeah, I get it. I mean, I understand that it's frustrating. I understand clothes are expensive, shoes are expensive. I trust me, I understand. But attorneys are expensive too, and they're probably more expensive than your clothes for your kiddos. So just kind of be mindful on all that.
Yeah, just don't send them over there in their fancy stuff. They're Yeezys, those $500 shoes, whatever they're called.
Did you call them Easy?
Yeezys? I'm not hip, but
You're not with it.
I'm not with it. No.
You're not dope.
Yeah, don't send them over there to expensive stuff.
I think they're called Yeezys.
Yeezys?
Old man, yes.
Do you have a pair of Yeezys?
I do not have a pair of Yeezys, no.
Can't even afford to say the word, so.
You only get 2 letters.
Yeah.
Okay, so the right to consent for the children to medical and dental care not involving an invasive procedure, so just regular doctor's appointments, easy breezy, and then the right to direct the moral and religious training of the children.
So that not involving invasive procedure came up a lot during COVID. Do you remember that? Whether to give the COVID shot or not give the COVID shot, whether the shot is an invasive procedure, and
Yes, yeah, we had that
Yeah.
come up quite a bit.
yeah,
What did we end up? What
it's
did
not
the
an
court-
invasive procedure.
That's what we ended up. So we had to research all of this, and there was case law that said that it was not invasive. But we still had a bunch of hearings on, whether or not kiddos could get vaccinated. And so, it just kind of depended on the discretion of the court, like most things in family law. So now we're going to get into.
You didn't say the religious one.
I did. Direct the moral and religious training of the children.
Oh, yeah.
Okay. So now we get into decision-making powers. Yep.
Dum.
So this is really going to be the primary differentiating factor, between joint managing and sole managing, right? So if you are a joint managing conservator, you will typically have decision-making powers over your children, okay? And there's different ways that these can be structured, and we'll talk about that here in just a second. But if only one parent is appointed as a sole managing conservator, then only that parent is going to be able to make decisions for your children. Okay?
So these are the rights for a managing conservator, be it joint or sole.
Yes.
Possessory conservator, no bueno.
No bueno. And so there's different ways that we can structure these decision-making powers. You want to talk about that?
Sure. So you can make them independent rights, which just means that both parents have the right to make these decisions. Doesn't require the other parent's consent, doesn't require a conference, they even accept the duty above that requires you to confer about anything significant. You can do it after a conference, like they have to confer first and then they can make the decision. You can do it by agreement. If they can't agree, you can do it by what the pediatrician says, or you can do them exclusive to where you're joint managing conservators, but this one particular right, only one parent has the right to make the child to make. The right to. Yeah.
It's Monday.
Independent, exclusive, after consultation. Is that it?
Independent agreement after consultation or exclusive.
Yes, those. That's what I said.
Okay. And so I will say most of the time we're dealing with independence. I think most attorneys will typically structure it independent, meaning either one of you can make the decision, right? I think it works a lot of the time to do it independent.
Yeah, the new statute that requires the marriage and military one to be by agreement only.
Right. And so, the by agreement, that is very much a double-edged sword, right?
See.
Yeah, so to make you guys, typically, in the context of divorce, you clearly couldn't see eye to eye, and even in the context of a SAPSA, you guys are separated, and so now what you're doing is you're having to come together to make these major decisions for your children. And a lot of our clients, thankfully, are able to get their crap together and do those things. Like, it's not even an issue, even though they can't be with one another. And so, the benefit is that you have to agree to every major decision for your kiddo, right? If there's going to be a surgery or educational decisions or whatever. The drawback is if the other parent won't agree to something that you think is important. You very well could be setting yourself up for future litigation, right?
And I don't even think it has to be a major decision, right? I mean, I litigated one of these over whether to have the child tested for educational.
Like the ARD stuff.
Yeah.
Mm-hmm.
I had this come up in, not a major decision, just have them tested, right? Not saying enrolling them or anything like that, but.
Mm-hmm.
So
Yeah. And so, it is, and like Floyd mentioned a second ago, a lot of times we will incorporate what we call tiebreakers. And so, if the parents can't agree, then the principal will decide, or the, counselor will decide, or the doctor will decide. I will tell you that those tiebreakers make me a little bit nervous because, number one, I don't know that we even should be incorporating those. Number two, a lot of times the principal is going to say, I'm not making this decision, right? This is a parent decision. And so now we're going back to court to say, hey, judge, we tried this and now we need your guidance because we can't, these two can't figure it out. That by agreement, there's pros and cons to it, and really that's a very personal conversation that we have, or I have with our clients, to say, here's what could happen, what do you want to do, right? The next one, as far as the exclusive rights, I see that quite a bit when we have certain issues that are going on with one parent. So if I have a mom who is taking the kiddo to the doctors every 5 minutes because she's worried something's going on with the kiddo, I have seen dad get exclusive, medical rights.
Or like if you got a child that has a severe illness,
Mm-hmm.
right? And it's been mom that's been primarily taking the child to these specialists and caring for that. We don't want dad coming in now take them to another doctor,
Mm-hmm.
things like that. So mom will get exclusive in that type of situation.
Right. I have had some judges that will just kind of randomly say, okay, exclusive right on this one to mom and exclusive right to this one on dad because you guys just can't seem to see eye to eye on anything. So now we're just going to split them, right? That's also something that can happen. So what do we say? Independent, exclusive, agreement, and conference. So I really like the conference. I kind of feel like that's my favorite. Because what it does, and you already kind of have that duty, right, that we've already talked about, to share significant information concerning health, education, and welfare. But when we're going through these decision-making powers, it really puts the responsibility on the other parent to talk to you about this stuff, right? And it doesn't mean you have to agree. It just means that you have to talk to them about these particular issues.
Yeah, and the problem with that is really the enforceability of it,
Mm-hmm.
right? I mean, conferring. There's the one judge that has added the word meaningful
Mm-hmm.
to it now. After meaningful consultation.
Yeah, or conference.
Conference, yeah.
And so I do think that it's important, though, because I think that if you're just like, I am going to take the kiddo to get their tonsils removed, this is my conference with you.
Yeah.
I don't know that would qualify them. So, there has to be some sort of dialogue that goes behind all this if you're going to get away with that.
What do you think about getting the tonsils removed? No? Okay, cool. See ya. You go get them removed, right?
So let's start with the first right. So the first one is the right to designate the primary residence of the children.
Yeah.
Okay.
It's generally exclusive.
It is generally exclusive. It's generally afforded to one parent, although it doesn't have to be, right? So there is a way to just make the primary residence of the children to a certain geographic area. But typically you see that is given to one parent, and I think we've already talked at length on geographic restrictions in another podcast, so we'll kind of leave that alone. And so next is to consent to medical, dental, and surgical treatment involving invasive procedures.
Yes, so this is the third time medical decisions have been mentioned. So the first time under the information rights, you have the right involving an emergency, right? So if there's an emergency, you can make the decision, right? The second one was medical decisions during time of possession. So when the child is with you, you take the child to the doctor. Now we're talking about invasive procedures, right? Surgery, removing arms, right? Which I think is generally surgical.
Tonsils is the one I like to use whenever I'm explaining it to
So I
clients.
thought about that, but I thought that's kind of boring. I'm going to go with an arm.
Okay.
There's actually a lot of case law on what's invasive procedure and not invasive procedure. I think there was one that came out recently about braces, whether that's invasive, right? Like we talked about the COVID shots. So that's what that is.
Okay, very good. So next is the right to consent to psychiatric and psychological treatment of the children.
Fun one.
I know. That was the sigh. So this one actually comes up a whole lot. And, typically you see it, unfortunately now, because we have a lot of kiddos on the, psychotropic medications. And we have, kiddos that are going into these behavioral health centers. We have one parent thinking that, oh, my kid doesn't need to see a counselor, and another one saying, yes, she absolutely does. And you have all sorts of these issues going back. One parent's keeping the kiddos on the ADD meds during their period of possession, and the other one's taking them off on their periods of possession. And so now you have this kiddo going back and forth on these crazy meds. And so that one comes up, unfortunately, quite a bit.
Or if you have a child that is in counseling, has made an outcry to this counselor, the other parent obviously doesn't like this counselor anymore, so take the child to another counselor to try to get a different opinion, and it's just a whole mess.
Yeah, and so that is actually one that I do see a lot of courts appointing exclusive rights, right? Especially like in the instance where we're talking about, not taking the meds, not taking them to the doctors. Judges are not going to be inclined for you all to mess with these kiddos' mental health, right? And so if you're doing that, then you're just going to get that right pulled, and the other parent will be able to make those decisions.
But I think there is something to be said to parents that overdo it, right? The parents that constantly taking them to counselors and psychologists and constantly having them medicated with psychotropic medications. Because we've seen that side too, right? Where that right will be stripped away from somebody that is overdoing it.
Right. And it's the same way, I think, with the medical, dental, and surgical treatments, right? And so, we've had that happen on numerous occasions where we have one parent who is consistently taking these kiddos for different medical procedures, etc., that did not appear to be warranted. And finally, the judge was like, no more. Like, I'm stripping you of these rights because, you've shopped doctors, and here's been the end result. You're not sharing this information with the other parent. You're not acting in the best interest, and so you're done, right?
See.
So, right to receive and give receipt for periodic payments for the support of the children, and to hold or disperse these funds for the benefit of the children.
It's a tricky one also.
Yeah.
So typically it's exclusive to the primary, the person that's designated as primary. Basically, generally what it means is the right to receive child support, right? But it could, in other situations, mean things like Social Security income if one parent passes away, and just different benefits that the child may receive. And so if that is exclusive to one parent, then anything the child gets by way of payment, Social Security or whatever, that one parent has the right to disperse or whatever, hold on to.
Correct. Next is to represent the children in legal action and to make other decisions of substantial legal significance concerning the children.
Yeah, that one never comes up. I don't know if I've ever had that come up.
No, I don't know that I have either, but you have it if you need it. And that's where we're going to leave that. So the right to consent to marriage and to enlistment in the armed forces of the United States.
Stupid.
Well, I know. Do you want to just explain why it's
Yeah,
stupid?
so you can't consent to marriage in Texas anymore.
Yeah.
It's not underage marriage, you can't consent.
It used to be a thing when we started practicing
Yeah,
because
and
we're old.
They've modified this crap so many times, but they keep that in there for whatever reason.
Right. And then decisions concerning children's education. That's, I think, kind of is self-explanatory. So,
Did you talk about the independent services and earnings of the child? No, you skipped over that one?
I think that's down below still. Yeah, it's chill out, Doug. We're on education. So,
Lord, you are dragging on forever.
when we're talking about education,
Use less words.
There's actually new language that we have started incorporating in orders where it says that a parent has the exclusive right to designate the school or to determine the school that the children attend, right? And so really when we're looking at this, we're looking at things like ARD, holding kiddos back.
Private school, homeschool.
Those types of, private school and homeschool. If you have a parent that has the right to designate the school, typically, that would be, I think, covered under there.
Yeah, I guess so.
Yeah. But those are typically the issues that we see. And sometimes it does come up, right? Like I've had, some situations where both parents go, they have these ARD meetings and they're told the same exact thing by, the teachers and the principals and, the professionals, and they walk out of there with two very different outlooks on what should happen with this kiddo's education. And if they have the independent right to make those decisions, then you're kind of like, well, dad's saying yes, mom's saying no. Now what do we do, right? So it has come up. We've had to go to court. Typically what we do is we haul in the principal and we haul in the counselors and we say, hey, what do you think we should do? And they tell the judge, and then whatever they say, that's what the judge is going to do. So when you find yourself in these situations, the courts are going to be inclined, I would say 90% of the time, unless this professional is a complete hack, they're going to follow their advice. And I have literally had a judge say, you're asking me to, or these parents are asking me to make a medical, professional decision. I am not a doctor. What is the doctor saying? Because that's what I'm going to do, right? So don't spend thousands and thousands of dollars litigating these issues if you have good, reasonable professionals that are telling you to do a certain thing.
Yep, I agree.
Yeah, unless you have another very reasonable professional that is going to come in and say, this is why you can't do it.
Which is then a nightmare.
Yeah, then it is a nightmare. That's a tough decision for the judge, and I'm glad I don't have to make those decisions, right? But, if you find yourself in that situation, consult with an attorney. They're going to tell you, best way to strategize that issue. So next, Floyd. You're so
Independent service and earnings.
You're very worried about this.
Yeah, I was interested in this one because I didn't know what it meant for the longest time. Do you know what it means?
So services and earnings, isn't that? I always say if it's like your child's like a movie star or something, and they get like money and they have earnings.
Yeah.
Yeah.
Pretty much right.
Yeah.
So where I had it come up was, one of my clients was going to have the child work for him in his business, and he would make money. Mm-hmm. But he wanted to make sure mom couldn't access those funds. But if it's both independent, then she would have the access, the right to access it.
Right. Yeah, I've never had it come up, but I always say, this is your right. So.
And services, make them do the dishes.
Yeah, mow the lawn, pull some weeds.
Yeah.
Absolutely.
Okay. Can you do it during the other parent's time?
Maybe, I don't know. So the next is, except when a guardian of the children's estate or a guardian attorney ad litem has been appointed for the children, the independent or the right to act as an agent of the children in relation to the children's estates if the children's action is required by a state, the United States, or a foreign government.
Never had it come up.
Never had it come up either. I'm sure it will one day, but
I hope not. I have to figure out what all it means.
You have to have that.
I'll just get a guardian or an ad litem appointment.
Right. So next is passports. So this is actually a right that is subject to the agreement of the other conservator. To apply for passports for the children, to renew the children's passports, and to maintain possession of the children's passports.
I don't like that language, subject to the agreement. Mm-hmm. I mean, I think I understand what the intent is, but usually the next paragraph down says that they have to agree within 10 days.
Mm-hmm. Unless there is a reasonable basis for withholding consent.
Right.
So I feel like we should do a whole other segment just on passports. Like we should put that down on notes because there's a lot to it. We typically have separate passport like language that we put in, and international travel provisions that we put in.
This is a new right that was just added a couple years ago or something.
Yeah. So, but you do have those rights, and then you have an independent obligation, DUTY, to manage the estates of the children to the extent the estates have been created by the community or joint property of the parent. So,
Yeah, same as before.
Yep, manage their property. So, I think that that's all of the rights and duties for joint managing and sole managing. I feel like we're missing some stuff. There's a lot more that goes to
I think
it.
just sum it up, right? Joint managing, you both have all of those rights, except one parent generally has the exclusive right to designate primary residence, which is where the kids live, and the exclusive right to receive child support.
Mm-hmm.
Sole managing, possessory. If there's a sole managing, generally there's a possessory. We're not getting into all that crap because it could not be, but that's a lot. Generally, both of you have information rights. One parent has decision making.
Yeah. So, like we said, there's different ways to parcel all this stuff out. It's very, very, very fact specific, and it's also very much dependent on your judge, right? And so we always tell people.
Hold on. And so if you watch this video and you think, that was incredibly confusing, these guys suck. It's true, it is incredibly confusing. We don't really suck. It's just
sometimes.
sometimes on Monday afternoons. Yeah, so it is very confusing. You can go 500 different ways.
Right. So consult with an attorney and talk to them about your particular situation. And so, as always, thank you guys so much for listening to us, for watching us. We appreciate the support. Find us on any social media platform that exists: TikTok, Instagram, Facebook, YouTube. Like and subscribe. Again, this is not to be construed as legal advice. Find yourself a good attorney that you feel comfortable with. Tell them your story and then listen to them.